greetings everyone to April's webinar. Thank you for joining us after the Easter holidays. Hopefully everybody had a restful period. This afternoon we're going to be looking at the April employment law update and what it means for you as employers, and we're joined by our favourite legal eagle Hayley Titchener from Invicta Law, and she's prepared a really comprehensive sort of presentation session for us this afternoon, and she's going to take us through lots of topics. So let's have a look at those. Okay, so we're going to look at taxation of termination payments and gain the latest insights around those. Going to look at some recent case law decisions, and in particular going to look at an interesting case around disability discrimination. We've got a case around pregnancy and maternity discrimination, and also one that includes a covert recording of a hearing and how and whether that information could be considered by the hearing panel. So be interesting to see what happens with those, learn what happened with those cases. We're also going to look at increases in national living and minimum wage payments, statutory payments, as well as employment tribunal awards. Obviously changes to those payments around this time of year, April increases. We'll look at increases in the Vento guidelines. Hayley will take us through those. We'll gain some insights into the Ministry of Justice and some recent statistics regarding employment tribunal claims, and we'll be looking to highlight there the importance of gaining HR and legal advice, and also look at forthcoming changes to look out for. So let's get started. Just to let folks know, actually, in saying that, those who are familiar with our webinar, you'll see your friendly webinar toolbar on screen there. Under the materials section, you'll find some additional information about Invicta Law, our partners, and you'll also find a copy of today's presentation as well if you want to take the opportunity to download that anytime during this afternoon's session. You'll have a copy of the slides. Okay, now let's get started, and we start with taxation of termination payments, don't we, Hayley?
Thanks, Emma. So good afternoon, everyone. Good to be back with you. So sorry to start the webinar with tax because it's not the most thrilling of subjects, but there's been some recent changes which will be relevant to all of you. So it's important you're aware of these if you're not already. So taxation of termination payments. So you're all aware that on termination of employment, an individual will often receive a compensation package which is made up of a number of different payments. So it's always been the case that certain payments will be subject to tax unless they fall within an exemption. So for example, someone's salary or accrued holiday will be subject to tax. So that's income tax, national insurance in the normal way. So the main exemption that you probably will all be aware of is the £30,000 exemption, which allows us to make an ex gratia payment or a compensation sum, potentially to compensate when someone has a potential claim against their employer, up to £30,000, and that payment can be made tax-free. And that will also be the case if you're making a statutory redundancy payment or a contractual redundancy payment. Again, that payment can be made tax-free up to £30,000. If payment is made and it is over that £30,000 threshold, then that will be subject to income tax only. So, looking now to what we call payments in lieu of notice. So on termination, an individual will be paid a sum to represent their notice. So often employment contracts will provide for what we call a payment in lieu of notice or a pile-on clause. And this allows an employer to terminate employment immediately and make a payment in lieu of notice instead of requiring the employee to actually work out their notice period. So their notice pay, if you like, is paid up front. Now, historically, schools and academies do not have pile-on clauses within their contracts of employment. And so as a result, when you as a school, as the employer, makes a payment to represent an individual's notice, and that's made immediately or upfront, so that employee is not required to work their notice, this is actually seen as a breach of contract, because our contracts do not allow for a payment in lieu of notice. So previously, as this has been seen as a breach of contract, the payment to represent the notice can be paid as what we call damages, and therefore tax-free. And so that sum to represent the notice will be included in the tax-free settlement sum, as I say, up to the £30,000. Any employer that has a pile-on clause within their contract would be required to make the payment of the net sum plus tax. But because we do not operate the pile-on within the contract, it's seen as a breach, as I say, can be paid as damages and therefore paid tax-free. So this is what you have probably been doing historically when you're looking at settlement agreements. Now, this position has changed. So as of the 6th of April of this year, when an individual's employment terminates on or after the 6th of April, all payments to represent notice will be treated as earnings, and therefore they will be subject to income tax and national insurance in the same way as salary. So this is the case whether there is a pile-on within the contract or not. So now, when you are looking to terminate an employee's contract of employment and you do not want that employee to work their notice and you want them to effectively leave and pay that notice up front, you will have to make a payment of tax on that sum. Now, just to note here that it's where the termination date is on or after the 6th of April. If you've currently got settlement agreements that have not yet been finalised, but the termination date is prior to the 6th of April, but you haven't yet made payment of your settlement sum, that will not be caught by these changes. So it will only be caught once the termination date is agreed as the 6th of April and after. So what does that mean for you? So what that means is when you're negotiating a settlement sum, you need to bear in mind that you will be paying the notice pay. So the individual will be receiving a net sum to receive their notice period. So that would be in the same way as if they were to work their notice. You now have to pay tax on that sum to HMRC. Again, very much in the same way as you would be required to do if they were working their notice. And then you would have to pay potentially any additional compensatory sum which is agreed on top of that. So if we just take a brief basic example just to help set this out. So say someone has a 3-month notice period and say they earn £3,000 per month after tax, and say the tax is £1,000 per month. So previously, before these changes to come into force, you would have paid that individual their 3 months notice, so their £3,000 per month, so that's the sum of the £9,000. And then the tax element, so the £3,000, you would not have had to have paid that to the taxman. You could therefore give that to your employee as a tax-free sum. So your employee would have been receiving the full £12,000 in their pocket. Now, because of the changes, you now have to pay the tax on that sum. So whilst your employee would still be receiving the £9,000 to represent their notice for those 3 months, the tax element, so the £3,000, now has to go to the taxman and can't be paid to your employee. So your employee is now only receiving the £9,000 in their pocket. So as a result, these changes are likely to mean that you may have to be increasing the settlement sums that you offer your employees in order for them to sign up to the settlement agreement. So this can just be a nominal sum, say like £500, maybe £1,000, depending on the circumstances you've got. But the situation is that the employee will only be receiving what they would be contractually entitled to if they were to work their notice. And so therefore they may want more for signing up to a settlement agreement. And you'll be aware that the purpose of the settlement agreement is obviously for them to waiver their rights to bring any claim. So therefore they may want an additional sum in order for them to waiver their rights away. And when considering, it's useful just to note when you are negotiating, and you've got to now seriously consider this point, it's also worth noting the use of your reference. So obviously in a settlement agreement, you have an agreed reference, and that can be very beneficial to some individuals, to some employees. So I just would bear that in mind when you are negotiating, that that reference can be used as the consideration, as the inducement for them to sign up now to the settlement agreement. I am just going to flag up to you that there is a formula as part of these changes in order to work out someone's pay for that notice period. It's unnecessarily complicated, and I'm not going to make reference to it here because your payroll providers will obviously be fully aware of that and will be using that with regards to calculations. But for your perspective, it is going to be ultimately the same basic pay, the same salary that that individual would have earned had they been working their notice. The other thing to just note before we move away from this is that it is very important that you ensure that where tax is payable, that this is obviously paid, because if you fail to do this, you will be liable as an employer potentially to pay the tax as well as penalties and interest on top of that. And HMRC has released recent guidance where they have indicated that if they have any concerns or issues with the way in which payments are made, and if there's any suggestion of avoidance of any tax, they will interview individuals, look at documentations, look at notes of meetings to establish exactly what has gone on, and therefore whether certain elements should be taxed or not. And again, finally, before we move away from this, just to give an example in relation to that, with regards to redundancy payments, so statutory redundancy payments and also contractual redundancy payments are still allowed to be paid as a tax-free sum. So that's not the notice, that's the actual redundancy payment. But obviously that is only when there is a genuine redundancy situation. So again, if HMRC have any concerns that people may be suggesting it's a redundancy situation in order to give an element of a tax-free sum, they have the capacity to go in, to get that fact-finding and to establish actually, is that the real reason? If there is not a genuine situation, then as I say, the employer leaves themselves open to risks of paying the tax as well as penalties and interest, which sometimes can be quite excessive. So obviously appreciate it's probably quite a lot to take in with regards to this kind of change, and it is important, and it is important for you when you are looking to negotiating your settlement sums. So what I've said to Sam and what we've put at the end of the webinar is our contact details, so please do not hesitate if you have any queries at all regarding this issue. Please do not hesitate to contact me, and either me or someone else in the team will come back to you to discuss this further if you need that.
Absolutely. As ever, folks, you're never on your own. You've got your HR consultants with SPS and, of course, our partners at Invicta Law. So do make use of the support and contacts that you have around you, and a really useful update on some quite important changes there. So hope that's useful. We make a slight shift now, and we look to explore some recent case law decisions. And Hayley's going to continue to share her knowledge and wisdom with us, and the three cases that we're looking at, in fact it's four cases, two relate to disability discrimination, one relates to a cancer diagnosis, and why the definition of cancer is particularly important, and the second is looking at whether an employer's knowledge of an employee's disability, the relevance of that, and what's the reasonable expectation and why that's important. So let's just take some time to look through the disability discrimination cases, and then we'll pick up on the other themes that we've got there. So over to you again, Hayley. Thank you.
Thanks, Summer. So yeah, so like Summer said, the first case we've got here concerns what amounts to a disability under the Equality Act. So in order for an individual to bring a disability discrimination claim, so whether that's a direct, indirect discrimination arising from harassment, or significantly the failure to make reasonable adjustments, they have to show they are suffering from what we call a disability. So under the Act, the disability definition is that someone is suffering from a physical or mental impairment which has a substantial and long-term, so that's usually 12 months or more, adverse effect on their ability to carry out normal day-to-day activities. Now, whilst the majority of individuals will have to satisfy this definition first, there are a number of disabilities under the Act which are called what we call deemed disabilities, and that includes conditions such as cancer, HIV, multiple sclerosis, blindness, and if someone is severely or partially sighted. If anyone is suffering from those conditions, they are automatically deemed to be suffering from a disability, and therefore they do not need to look to satisfy the definition. So in this case we've referred to here, Lofty and Harris, this concerned a case where the employee actually suffered from a precancerous lesion which could have resulted in skin cancer. She had successful treatment to remove those cancerous cells before they resulted in skin cancer. And the issue before the tribunal was the employee suffering from a deemed disability on the basis she was suffering from cancer, even though at this stage they were at precancerous cells. So the decision, in fact, the tribunal initially said as she had received successful treatment for the precancerous condition, she never actually got to the point where she had the cancer, and therefore she was not suffering from a deemed disability. This was appealed, and the Employment Appeal Tribunal had a different view in relation to this. They noted that the law doesn't distinguish between invasive and other forms of cancer, and that there was no justification for the introduction of distinctions between different cancers, or for a tribunal to disregard cancerous conditions because they have not reached a particular stage. So ultimately, any diagnosed pre-cancer conditions are deemed disabilities, and therefore will automatically provide the sufferer with protection under the Equality Act. So you just need to be aware of this. So like I say, anyone with precancerous conditions as opposed to the cancer itself now will be classed as a deemed disability, and therefore in order to minimise any risk of any potential claims, and particularly the failure to make reasonable adjustments, you obviously need to be taking your HR support, getting that medical advice, taking legal advice if necessary at an earlier stage to ensure you are putting in place those reasonable adjustments and meeting your obligations under the Equality Act.
Lovely, thanks for that. And as ever, as Hayley says, make sure that you're gaining advice, and we're here to help. The next of the cases, so still, as I say, under the theme of disability, is this one. Talk to us about this case.
Yeah, so we've also just looked at the definition of disability. Now we're going to look at knowledge, so what an employer is expected to know or look for with regards to establishing if someone has a disability. So this is particularly relevant with regard to the obligation for the duty to make reasonable adjustments. That duty only applies if an employer knows or could be reasonably be expected to know that an individual is suffering from a disability. So ultimately, an employer must make reasonable inquiries to establish if an employee is disabled. They can't just plead ignorance, basically, and say, oh, we didn't realise they were disabled, we didn't bother to kind of look into it any further, so therefore we don't need to make reasonable adjustments. You cannot plead ignorance. And the case I've set out here is a recent Court of Appeal decision. So we had an employee who worked for nearly 10 years. She started arriving late, having issues with regard to low energy levels. She said she was tired in the morning. She was absent for about 128 days in the last year of her employment. her employer referred her to OH. She was quite uncooperative in relation to that. And the OH report indicated that she wasn't suffering from a disability and stated that her problems were managerial rather than medical, which we've probably seen quite a few times. She continued to take time off, and in the end, her employer instigated disciplinary proceedings. In that time, the GP provided further information that her sickness leave was due to work-related stress, and they also didn't confirm one way or the other whether she was suffering from a disability or not. Eventually, she was dismissed for unsatisfactory attendance and her failure to comply with procedures and failure to work her contractual hours. She brought a claim for unfair dismissal and disability discrimination, including failure to make reasonable adjustments. Now, at the tribunal will have to look at whether someone is actually suffering from a disability. And in this case, the tribunal actually said that yes, for the last 2 months of her employment, she was suffering from a disability. So the question then was, could the employer, with the information they had gathered, have reasonably been expected to know that in fact she was disabled, and therefore was her dismissal potentially discriminatory, and had they failed to make reasonable adjustments? Now, both the Tribunal and the Employment Appeal Tribunal dismissed the individual's claims, and particularly in relation to the making of reasonable adjustments. And this was on the basis the Tribunal said the employer had obtained a wide range of information to conclude that the employee was not disabled, and therefore they could not have known or could not reasonably be expected to know that she in fact was suffering from a disability. Now, those decisions were appealed, and as I say, the case went to the Court of Appeal, where again they considered the issue as to whether the employer could have reasonably known the employee was suffering from disability. And the Court of Appeal agreed with the Tribunal and the Employment Appeal Tribunal and said whilst the GPs didn't give a clear picture as to whether she was disabled or not, they didn't rely solely on that. They had advice from OH, which said she was not suffering from a disability. They'd held meetings with the employee to get her point of view with regards to her condition. And so in their eyes, the employer had done all they could reasonably be expected to do to find out about her illness and to try to establish whether that was a disability or not. It's quite useful to actually contrast this case with an older case of Gallup and Newport City Council. And in that case, the employer relied solely on an occupational health advice that stated that the employee was not disabled. They didn't question that advice. They didn't seek any further information. They didn't meet with the employee to discuss her condition. They just literally took that OH advice and basically ran with it. And the Tribunal in that case held that they could have reasonably known she was disabled if they'd questioned further or if they'd sought any further information. So these cases are just useful for you to understand that whilst as an employer you're not expected to look at every possibility, you also on the upturn do not take your OH report and take it when it says that someone is not disabled as gospel, if you like. Get that more information just to check and be sure that you are happy that individual is not suffering from a disability. Okay.
Lovely, thank you. And our next case relates to pregnancy and maternity discrimination. So what happened here?
Yeah, so this is an interesting case actually with regards also to the importance of documenting your reasons for dismissal. So in this case, we had an employee who was on her probationary period. The employer decided to dismiss her due to performance and conduct issues. So she was taking too many cigarette breaks, she was wearing incorrect uniform, and there was an incident with one of her colleagues. So a meeting was held with her on the 3rd of August, and a decision was taken to dismiss her due to her emotional volatility and failure to fit in with the employer's work ethic. A letter was drafted in order to communicate that decision to her, but it was decided that they would give that letter to her confirming her dismissal once she came back into the office. Before they had the chance to give that letter to the employee, she came in and she informed them that actually she was pregnant. The next day, after being informed of that, they gave her the letter and confirmed that she was to be dismissed. She then pursued a claim for pregnancy and maternity discrimination because she said she'd been treated unfavourably because of her pregnancy, and also brought a claim for what we call automatic unfair dismissal, again because she says the reason or the principal reason for her dismissal was because she was actually in fact pregnant. The tribunal actually said that whilst the decision was made prior to the employer's knowledge of her pregnancy, it would have been obvious to them that her hospital appointment and the emotional issues that they'd witnessed from her would have been due to her pregnancy. And they held that a failure to reverse the decision once they were aware of her pregnancy was actually discriminatory. Now, this decision was appealed, and the Employment Appeal Tribunal felt that actually, in fact, there appeared to have been no further discussion after the 3rd of August about her dismissal, and therefore it could not have been motivated by her pregnancy. Now, what the Employment Appeal Tribunal has done is actually put this case back to a different tribunal for them to just consider whether there was any additional decision made once the employer was aware she was pregnant with regards to her dismissal. So ultimately, if there's any indication that they were dismissing her because of her pregnancy, then her claims for discrimination and automatic unfair dismissal may well be made out. So what this case is important for you as employers is to document your reasons for looking to dismiss someone. So in this case, it would have been for her performance and the conduct issues as opposed to her pregnancy. And if you've got any issues with regards to performance, for example, or conduct, that you look to deal with them at an early stage so that it's clear the reasons if you are then coming to look to dismiss someone is because of those performance concerns or conduct concerns, as opposed to anything else that may turn up after that date. So it's just important to deal with them, like I say, at an early stage, and to obviously document your decision making so that you can show the reasoning for any decisions that you make.
And certainly in terms of this case, remembering that she was within her probationary period, so we're not just talking about substantive staff members that go through a formal hearing process, we're talking about any decisions to bring employment to a close. And actually in an earlier webinar, do get yourselves on our website and have a look at our back catalogue. We did a session looking at effectively managing probationary periods and induction, and within that we gave a whole series of sort of advice and guidance, and there is a probationary period checklist that you can gain access to, which helps you in managing the necessary sort of meetings and contact points to review performance, conduct, hopefully to confirm the person in post, it having been a successful period, but also gives you those very practical advice and guidelines in managing those probationary periods where there are issues such as this case, and the importance of recording those.
Yeah, completely, definitely. And they'll obviously be very useful to you. So yeah, as Summer's touched upon there, for anyone to bring a discrimination claim, they don't have to have their 2 years service like you may have heard of for unfair dismissal. So yeah, exactly. When someone's in their probationary period, that is still a concern. And again, with regards to here, she brought a claim for what we call automatic unfair dismissal because of her pregnancy. And again, she does not require 2 years service in order to bring such a claim, and so hence why, as Summer has touched upon there, is important for you to still be aware of that, even though someone is only in their probationary period.
Yeah. There was just, I think, a final thought on this case, wasn't there? Maybe not then.
Yeah.
Okay, we've covered
that.
But just to really bring home the points, some thoughts for you there on screen, so that when you're referring back to your notes, you've got those there. Okay, let's move swiftly, if not comically, onto our last case then, where we're looking at covert recording. And can a covert recording of a disciplinary hearing be used as evidence in an employment tribunal?
Yeah.
What say you, Hayley?
This is a really interesting case, actually. So what we had in this case was an employee who failed to attend an OH appointment, failed to attend a meeting with his manager following a period of absence. So he was called to a disciplinary meeting. During that meeting, it was actually adjourned because the employee then agreed to meet with his manager and agreed to attend an OH appointment. Now, unknown to the employee had actually covertly recorded that disciplinary meeting and had also recorded the breaks that took place during that meeting where the panel had obviously discussed the matter. So on the recording, comments were made which were robust and sometimes inappropriate in terms, and there was also reference to advice that had been given by the trust solicitors and a telephone call that had been made to the solicitor. After listening to that recording, the employee decided, I'm not going to attend this OH appointment and I'm not going to attend the meeting because obviously the decision has already been made by the employer. And because he failed to attend those meetings, he was then actually eventually dismissed for gross misconduct. Now, the matter obviously proceeded to an employment tribunal, and the employee wanted that covert recording admitted in evidence during that hearing to show why he didn't go to those meetings and therefore why he was eventually dismissed. Now, the employment tribunal initially said, no, you're not able to use any of that material as it was a covert recording at the full hearing. That was appealed, and the Employment Appeal Tribunal held that firstly, due to legal professional privilege, which covers communications between a solicitor and a client for the purposes of obtaining legal advice, that all references to advice from their solicitors and the conversation between the panel with regards to the solicitor was privileged and could not be used in the tribunal hearing. It's worth just noting here for you guys that that privilege does not extend to HR professionals. So there's no such privilege with regards to conversation between your HR support and yourself. It's just with regards to legal representation. So the tribunal held that, okay, all the elements that where there was a discussion with the solicitor, that's privilege, that's not to be allowed in as evidence. But what the Employment Appeal Tribunal did state is that there was a balance to be held between the public interest and the interest of the employee to be able to use the rest of that evidence, regardless of the fact that it was covertly recorded. Now, the tribunal noted that the discussions recorded were not expressly stated to be private deliberations and that they were not final deliberations, although the tribunal did state that they did obviously relate to the hearing and the decision, so there was a strong public interest in preserving the privacy. But because the employee had listened to the recording very soon after it was made, that he'd been upset by it, and this had contributed to his decision making not to attend that OH appointment, not to attend the meeting for the employer, and that was the reason why he was dismissed. The tribunal felt that they could not properly make a decision without reference to the content of the discussion, and so that evidence was allowed to be admitted even though it was covertly recorded. So now clearly the panel's deliberations here took place between breaks in the hearing. So this case is just important to flag up here that if obviously you are recording hearings, which you often do and which is a good thing to do because you're getting a true reflection of the discussions, that if the matter is paused for breaks, etc., that it's very important the recordings are stopped if you are recording it, obviously, and just to be careful as to what is said during those breaks and to maybe try to keep deliberations to the end of the hearing, or maybe if you're in a different room, etc. It's also worthwhile at the start of such meetings to maybe just say, obviously, the matter cannot be covertly recorded. Clearly, that's not going to stop any employee doing that, but sometimes it's worth mentioning that. So it's just a case really to just make you aware and just be careful of discussions that you're having during the hearing and during those breaks, just in case it is being covertly recorded, because based on this case, it was allowed to be admitted.
Interesting. Okay, again, we take a slight shift and we move away from our cases excuse me, and we now look at increases to national living and minimum wage and statutory payments, and of course the Employment Tribunal awards. Now, the information is in essence presented there on screen, so what I'm going to do is take the opportunity just to show the slides on screen and give you an opportunity to have a quick look through those. Of course, if you've downloaded the slides, you'll have these freely available to refer to at your leisure. And of course, increases to the national living and minimum wage are of course reflected in the new Kent range pay value. So if you're working with those will have been reflected, and actually in last month's webinar we picked up on support staff pay. So you again get yourself on our website and have a look at our back catalogue if you're looking, if you have your own localised pay framework, then of course you'll be needing to make sure that these are reflected. So national living and minimum wage values there on screen, those took effect as of the 1st of April, and rates will now change every April as opposed to October, so a date for the diary there. So there you go, those are on screen. We also have some changes to the family-friendly allowances, so from statutory maternity pay through to paternity pay, adoption and shared parental pay, and again those values there are on screen for you to both view now but also to refer to at your leisure. And again our policies relating to family friendly leave and provisions will of course have been updated, and there has also been some changes to Employment Tribunal awards, and again those are on screen there in terms of the compensation limits. Those rates took effect from the 6th of April, so again for your information there and referral. There's also been an increase to injury to feelings award, and we do just want to take a bit of an opportunity to explore this in a bit more detail, don't we?
Yeah, of course. So again, these awards have been increased for claims which have been presented on or after the 6th of April. So injury to feelings award can be given in discrimination claims in the main, also whistleblowing claims, but they are mainly, you need to be aware of with regards to any discrimination claims which may be made against you. So with regards to injury to feelings, we have what we call the Vento guidelines, which provide for 3 separate bands in relation to the injury to feelings awards. Now, the onus is on an employee to establish the extent of their injury to feelings. So this looks at potentially anger, upset or humiliation that they may have felt as a result of any discriminatory treatment, whether any treatment has led to them suffering from a particular medical condition or loss of confidence. And they are assessed on someone's individual personal characteristics. So if one person finds something particularly aggravating that another may not, it's based on that subjective personal characteristics. So just looking here at the 3 bands, so the upper band is for your most serious cases where there's been a lengthy campaign of discriminatory treatment. So that campaign and the treatment may be where it's particularly targeted, where it's deliberate, repeated, consciously inflicted, or where there's been a considerable amount of hurt and anguish, damaged confidence and self-esteem. So as you can see, those figures range now from 25,700 to 42,900. And there is the possibility for some exceptional cases, although they are exceptional, of exceeding that £42,900 award. The middle band are for cases that do not merit an award in the upper band, and that can be sometimes looking at cases here where people have felt physically sick, suffered setbacks in medical treatment, some people who have stopped studying for degrees, affected their personal relationships as a result of the discriminatory treatment. And as you can see, the sums there are from 8,600 up to 25,700. And then your lower band is for your less serious cases, so that's more for your one-off discriminatory incidents. And again here, your compensation with regards to injury to feelings is now increased and is between 900 to 8,600. So your discrimination claims, an individual will not only have a claim or be able to present a claim and an award for injury to feelings, they will also potentially be awarded for loss of earnings as well. So it can be a significant award, and claims for discrimination are not capped like they are for your unfair dismissal claims, so they notoriously can be particularly high. So again, just something for you to obviously be aware of.
Lovely. And in terms of watch this space and something to be aware of, we've just got a few more thoughts to share with you. So here what we wanted to be able to highlight and share with you is that following the abolishment of tribunal fees that took place back in the summer last year, the Ministry of Justice latest sort of figures that are out shows a significant increase in the number of employment tribunal claims. So just again, in terms of individual staff are fully aware of their rights to refer claims to the employment tribunal. There's certainly been an increase, and of course just the value as ever in making use of the support that you have around you, the contacts that you have around you, ourselves as SPS and our HR consultancy, as well as our partners at Invicta Law, to gain advice in those HR employment issues, that complex casework, and we're here and readily able to support you with those issues, much like the cases that Hayley kindly outlined for us. Something else to look out for. The future is bright. The future is
not orange. So I've just set out here just a couple of things for you to just be aware of that are potentially coming up in the future. So the first one we've just set out here is that the government has recently launched a consultation into parental bereavement leave and pay. So what they are proposing at this moment in time is that someone who has 26 weeks service should be eligible for a rate of parental bereavement pay, potentially for a 2-week period. At the moment, the consultation is focusing on what a definition of a bereaved parent is. So, for example, would that include a step parent? It's looking at how and when parents might take leave and what kind of notice and evidence may need to be provided. So that's only at a consultation stage at the moment in time, and that consultation closes in June of this year. So just something really for you to be aware of.
Yeah, and what's lovely is that having the involvement of Invicta Law in our monthly webinar series, you guys kindly join us for the April employment law update. You join us again in October, because again there's another round of employment law that is released at that point in time, and you also kindly join us in February as well. So ample opportunity for us to keep you updated as this consultation progresses and ultimately when law and guidelines are published. So we look forward to some more information around that. The future continues to be bright.
So yeah, just on a similar kind of remit here, again, we've had previous consultation plans from the government with regards to introducing shared grand parental leave. Now this consultation on proposals came about in late 2015. Now the consultation has actually been paused because of Brexit, and no further consultations have been issued as of yet. So again, this is a little bit on the back burner, but again it's something for you to just be aware of that might come up in the future.
Absolutely, and we'll continue to keep you updated. The future, as ever, is bright. General Data Protection Regulations, or GDPR, I'm sure you will have heard that phrase. It comes into effect from the 25th of May 2018. We've been doing a lot of work in looking to support you as schools and academies in preparing yourself for GDPR. However effective you are in terms of managing data protection at this moment in time, GDPR is next level in terms of accountability, responsibility for data protection. So there is work for everybody to do in terms of getting ready for this. I've shared a copy of our webpage there on screen. We've got a webpage dedicated to GDPR with a wealth of information and resources. So do look to get yourselves online and access that. We've got training sessions and support readily available to you. So take a look and get in touch if you need to. Just a couple of last thoughts.
Yeah, so again, back to tax again, actually, so I'm not sure the future is so bright, but where we touched upon, obviously, earlier, the taxation of the termination payments, we touched upon the fact that if anyone is paid a tax-free sum over that £30,000 threshold, at the moment, that sum over that 30,000 is only subject to income tax. Now, changes will be coming into force when, in fact, that sum will be payable to income tax as well as employers' national insurance contributions. It was thought that that change would come in at an earlier stage, but it looks like that won't come in until April of next year. So there's a little bit of time, but again, something for you to be aware of. And just keeping on that point, I've just put in a last slide here of kind of what ever happened to, and this is a kind of another thing that we are waiting for here, that there's been a suggestion that legislation would come in to restrict public sector payments, so your termination payments, up to a maximum figure of £95,000. And there was also a suggestion of repayment of any termination sum if an individual returns to a role within a public sector. Now, again, this has been on the back burner for a little time, and hopefully that legislation will come to fruition shortly. But again, something for you to be aware of, and we will of course update you as soon as any further movement is made in relation to that.
Absolutely. So just in terms of final thoughts, don't leave us just yet, but in terms of final thoughts, we're here and happy to help. You know our details as SPS. Here are the details of certainly Hayley, our resident legal eagle, and Invicta Law. So if you would like additional advice and support, then you have those contact details there. And Hayley, along with colleagues, is always happy to help. We love Hayley. And final thoughts then, our future webinars. So May, we're going to look at flexible working with practical tips covered, as well as looking at the legal considerations. June, we're going to share some practical tips for developing and reviewing job descriptions, and we're going to have a particular focus on moving away from a list of tasks and how you can actually go about framing accountabilities and make those job descriptions all the more fit for purpose and robust. And then July, we're going to again support you with looking at developing your HR and training plan for the next academic year. So hopefully some useful content there for you. And we hope to welcome you back to see out 2017-18 at one of those events. As ever, visit our website, lots of information, including a full list of our training and events. And we hope to see you in person along the way. Thank you for joining us today. Thank you, Hayley. Always a pleasure. Have a great rest of the week, folks. We'll be posting this video online in the coming days. If you want to revisit, make sure you download those slides, and we'll see you again very, very soon. You take care. Bye.
Bye-bye.